I'm just making sure that there's not still Coca-Cola flowing all over the table over there. Okay, we're back on. Counsel present and defendants present, represented by counsel. We are discussing on page 19 the contemporaneously language. So tell you how the court's going to charge this. I don't read the statute the same way as the defense. There's I read into the statute. The first line addresses both felonies and misdemeanors. The second sentence narrows that then down to felonies. It doesn't discount misdemeanors. It just says in the case of felonies, if there's an escape going on, then the arrest can be effectuated. The way I read that is if it's a misdemeanor, the guy can be arrested, gal, whoever it is, can be arrested by whoever is effectuating the citizen's arrest. But if they run, then you can't go chasing after misdemeanors. In the case of a felony, you can. And a person who is chasing somebody who's escaping on a felony that is justified upon reasonable and probable grounds for suspicion can effectuate the arrest. So the charge that I am going to provide, I'm going to amend a little bit from the state's language, and that is that a private citizen's warrantless arrest must occur immediately after the perpetration of the offense, or in the case of a felony, during the escape. If the observer fails to make an arrest immediately after the commission of the offense or during escape in the case of a felony, his power to do so is extinguished. I'm not going to comment on the legality or illegality, so I'm putting a period at the end of extinguished and removing the "and a subsequent arrest is illegal." So, again, private citizen's warrantless arrest must occur immediately after the perpetration of the offense or, in the case of a felony, during escape.
I'm sorry, could you say that last portion again?
Or in the case of a felony, during escape. If the offender fails to make the arrest immediately after the commission of the offense or during escape in the case of a felony, his power to do so is extinguished. That's what the court intends to charge. I understand there's an exception from the defendants.
Judge, if you charge the jury the way you're contemplating, you are directing a verdict for the state. You are rendering the second sentence in which it describes reasonable and probable grounds of suspicion meaningless. It's in there presumably for a purpose. It's a different burden than immediate knowledge or presence. And so I would urge the court to reconsider and eliminate this, let the state argue what they're going to argue. We have built this whole case around the probable cause, the second sentence, last phrase that Travis McMichael and Greg McMichael had on February 23rd for events that happened previously. And you are gutting all of it if you give this particular charge.
May I ask, Your Honor, if, I know we're Friday at 2:30, if over the weekend we were able to email to you or your staff a full, complete with citations argument for what position we're arguing for here, that this contemporaneity of the offense for which you are fleeing and being chased.
Why don't we do this? This is what I intend to charge. I'm not going to reopen all of the charges. I understand the significance of the charge that is presented. I will, if I'm provided something, at least on a timely basis over the weekend, where I can digest and the state then have an opportunity to digest and respond. This charge, I will remain, the intent is as I've described. But if I'm provided different authority than I've already been provided, I will go ahead and reconsider upon the presentation of any additional authority that may come.
Could I shoot for, say, midday tomorrow? I'll be working on it all morning, tonight in the morning. not Sunday, but sometime tomorrow, get it to the court. And
That's fine.
and at some point, whatever other email addresses you'd like me to use, I'll use. I may have them all already.
Yeah, I think you've got just about everyone we've got.
Okay.
I can't think of any more that hasn't been provided.
Your Honor, I think I've already submitted all the law that I can find, but we'll certainly be happy to adopt what more learned co-counsel can submit. But I agree with Mr. Rubin. And I'm not saying that it's the intention of the court. I don't want to be misunderstood. But the practical effect of this charge is a directed verdict of guilt. And it's a denial of the sole defense of at least 2, if not 3, of the defendants in this case. I mean, I think the court's indicated the court appreciates the gravity of the charge, but I'm just joining in that because that's just the way it is.
Okay. Understand where we are.
Thank you, Judge. So the next one that the state submitted would be State's 56, and that is probable cause is not enough for citizen's arrest. The state is requesting that this charge be read based on Arbery versus Collins 1995 case 219 Georgia Appeals 63. The existence of probable cause standing alone is not a complete defense in a false imprisonment case, because even if probable cause to believe a crime has been committed exists, a warrantless arrest would still be illegal unless it is accomplished pursuant to one of the exigent circumstances applicable to private persons, which include the fact that the crime committed was a felony and that the felony offender is escaping or attempting to escape. Now, Judge, the state will go ahead and concede a few things about the Arbery case. Arbery versus Collins was, once again, a civil case. It was an apartment complex case. It had to do with a...
Can I stop you? Isn't this simply an expansion on what I just addressed?
Yes, it is.
Okay.
Your Honor, we're prepared to argue, but I suppose we could argue all day. This is not the law as applied to this case. You have just earlier said probable cause is what you're looking for in order to support the definition necessary for a citizen's arrest. And now to say, yeah, but that's not enough, is only applicable when you're talking with respect to these civil suits.
Yeah, my concern about this is I probably need at some point to look at how many times I've said on the record something's being conflated during this trial, but I feel like I need to come up with a better word. We're conflating probable cause and exigency in this charge, and I think the charge above addresses exigency, and there is a probable cause charge. So that's my concern about it from the state.
I'm still going to ask that you give it, but I understand if you choose not to, Judge.
Anything from the defense on that, I don't intend to give it. I think it's covered.
We ask that you do not.
And for Mr. Bryan?
One could make the case that it's less damaging than the one before, but I'll join in the co-defendant's motion to exclude that one.
All right.
Thank you, Judge. So I believe the next one is probable cause done by the defense. And the state objects to this particular charge as given by I believe the court has, they've submitted one, it's a little different than the court has, so I'll read the one the court has. A private person may arrest...
May I say this? To be fair, we're now talking about the request that we've submitted, and I feel as if I have to defend
Yeah, let's do this.
each one of them.
Let's hold on to it. One, if the state objects to that, so I'll just put an objection, and I'll let the
Okay.
defense address that.
All right. I assume that's the same for the next one. Probable cause is a question for the jury. Whether the defendant possessed reasonable and probable grounds for suspicion is for the determination of the jury.
If it's objected to.
It is objected to.
Okay.
Well, actually, no, you know what? I actually think that's the correct statement of the law, because whether the defendant possessed reasonable and probable grounds for suspicion is a determination that the jury has to make.
It's not that next one requested by the state.
the next one requested by the state.
They may not arrest upon suspicion alone.
Yes, Judge. So this one is basically, there is no authority in Georgia under which a citizen may be arrested without a warrant and held for investigation to determine if he has committed some crime merely because the person making the arrest has a suspicion that the person arrested may have committed some then unknown crime. Once again, we have Rife versus the state, R-A-I-F versus the state, 109. Georgia Appeals 354, 1964 case. That conviction was reversed where the defendant was arrested for walking near a shopping mall, and he was a suspicious character, probably an intruder, and he was illegally arrested, and then hours later it was discovered that the store in the mall had been burglarized, so they connected it up somehow later, but there's no evidence that he had been the one who had burglarized it. So in that particular case, it was just based on he's a suspicious character, and they arrested him because he was walking near a shopping mall. So based on that, you can't arrest somebody just because you have a suspicion that they may have committed some then unknown crime and then go looking for the crime, which is what they did. They said, well, he's suspicious, let's go check the mall, and oh look, the mall's been burglarized. Forehand versus the state, 130 Georgia Appeals 801, 1974 case, holding that in his presence and words with his immediate knowledge are synonymous. But they went on to say that to justify the arrest without a warrant, the officer need not see the act which constitutes the crime if by any of his senses he has personal knowledge of its commission. What the officer sees must be what he sees before the arrest and not afterward, finding illegal the detention and subsequent arrest of the defendant solely based on a reliable informant telling the officer that the defendant was engaged in the business of burglary, but the informant knew of no particular burglary, and the officers did not see or know of any particular crime the defendant had committed. Basically, what the state's getting at here is Greg McMichael tells the police, I think he must have gone and committed a crime, so we were going to hold him so the police could show up and then figure out what crime it was that he committed. The state really wants the jury to understand that you can't do that. Under the law, you can't go, suspicious character, we're going to hold you here, we're going to detain you in violation of your personal liberty because we're going to call the police now because you're a suspicious character, and we're going to go ahead and then later figure out what crime it is that you must have committed like they did in Rafe. Smith versus the state, the 2012 case, 314 Georgia Appeal 583, specifically on this point. Significantly, Smith testified that he was not present when the money was allegedly taken. His suggestion that the victim had committed the theft was based upon mere speculation. Smith's claim that he wanted to question the victim reflected that he was uncertain and did not have immediate knowledge that the victim had been the perpetrator of the alleged theft, which is required for a lawful citizen's arrest. So what we've got going is that this whole idea of, well, he's a suspicious character and he's been inside that house a couple of times and some stuff had been stolen and all these things, we're going to go ahead and detain him to investigate. And Judge, that's exactly what Mr. Rubin said in his opening statement, that he was doing a citizen's arrest to detain Mr. Arbery so that the police could show up and do whatever they wanted to do to investigate to find out what crime it was that he must have committed. That's a false imprisonment. That's an illegal citizen's arrest. And the state is very concerned that somehow the jury's going to think that detaining people for the police so they can figure out what crime they must have committed is somehow lawful. And it's not. It's false imprisonment, and it falls under that. So the state is asking for, there is no authority in Georgia under which a citizen may be arrested without a warrant and held for investigation to determine if he has committed some crime merely because the person making the arrest has a suspicion that the person arrested may have committed some then unknown crime.
Yeah, our response is that this request number 57 is not applicable to the facts of our case. We did not open by saying we had no idea what crime Mr. Arbery might have committed. There's some unknown crime. He's just suspicious. We're going to hold him and let the police figure out whether he committed a crime and what crime it may have been. The way the evidence has come out is, as we've said all along, we suspected him of a specific particular crime that we could articulate and identify and have reasonable and probable grounds to suspect him of having committed. Burglary in the English house. So while these are correct statements of the law, in Rafe it says you can't just arrest somebody without a warrant because of suspicion of some then unknown crime they may have committed because they're lurking around a shopping center. Yeah, that's the law, but that's not applicable to the facts of our case. So this charge just doesn't apply, and that's why it should not be given.
Your Honor, we agree and join Mr. Hode's argument. You know, we have a continuing problem here. You know, I see it becoming a problem during on Monday. The state keeps, while the citizen arrest statute is the authority that I understand the McMichael defendants to be traveling under, although the statute uses the term citizen arrest, arrest encompasses detention. And this charge is misleading to the jury. There's never been any suggestion that anybody intended to grab Mr. Arbery and shove him in the trunk of their car or the back of their truck, hog tie him, and take him down to the Glenn County Detention Center. The uncontradicted evidence has been the intent to detain Mr. Arbery momentarily for the arrival of the police. Now, I think Ms. Dunikoski and I agree that that is not authorization to be Nancy Drew and to hold people for the police to see whether there's a crime. But when there is an articulated crime that the detention is being sought for, then to be continually referencing arrest in these charges is incorrect. To be tailored and adjusted to the facts of this case, although the jury should be informed it is a citizen arrest statute, the jury needs to understand and the subsequent charges should refer to detention, which is authorized based on probable cause. And what Ms. Dunikoski is doing is conflating the permissible and impermissible in these charges. So to say that you can't arrest someone for investigation, determine if a crime is committed, that is true. But you can detain them if you have probable cause to believe that a crime is committed. You do not have to physically take them down to the jail. You can hold them for the police as long as, for a reasonable time, as long as you have probable cause to believe a specific offense has been committed. And this, again and again, through the charges submitted by the state, the way the state is using the word arrest is creating a problem here, because in almost all these instances, when we talk about arrest, what we should really be telling the jury is they're authorized to detain, because that is adjusted to the facts of the case.
I would also just ask the court, consider using that word detention. The detention is an arrest. It's not taking them in handcuffs. It is stopping them and detaining them for the suspected and believed conduct that is illegal. The state is then going to be allowed to articulate what arrest means without further definition or further limitation by the court. I think the court needs to consider that citizens, or you've heard the state's cross-examinations throughout this case. Did they say you're under arrest? Did they say we're making a citizen's arrest? To say that we're going to stop and detain somebody, we're going to stop them for the crime that we believe they committed, that is a citizen's arrest. But the other problem with what the state is asking for here is it's allowing the jury to be confused. It's going to be confusing to the jury if you further allow this charge to have the state explain some unarticulated motive.
Let me focus back on the charge. So here's where I'm on this charge. One of the other challenges associated with this charge in language is the upon reasonable and probable grounds of suspicion. Okay, that language exists as stated in the statute, and it sounds like, until I say this, that everybody agrees that that's probable cause. That you need probable cause for an arrest. The fact that you put suspicion in there, my concern is with the jury that creates confusion. And so depending on what the probable cause charge is, which is what has been objected to by the state and is being proposed by the defense, it's hard to say whether or not this suspicion language is necessary. Because again, my concern is any confusion the jury would have with the upon reasonable and probable grounds of suspicion. primacy and recency. The last thing they hear is suspicion. All of a sudden, it's just suspicion that allows folks to act. I do think that probably needs to be defined or clarified. And so if the charge for probable cause is simply left the way that it is, I'm more inclined to put in, and probably not this exact language, but some language explaining that you can't just act on suspicion, to clarify that. So that's where I stand on it. I'll come back to it again then when we talk about probable cause. But if we can somehow attach those concepts together so that there isn't that gray area that sits there with the word suspicion being used in effectively the definition of probable cause, then I'm happy to go ahead and hear from you.
I think everybody agrees that you can't detain someone on mere suspicion. And I think that's what the court is driving at.
No, that's exactly what I said. What I said is that the problem in this case is the statutory language uses the word suspicion. And so when a jury hears suspicion, my concern is it adjusts what people think or pulls them away from lawyer language, probable cause, which everyone agrees is really what we're talking about. So hopefully I explained that well enough so that we'll be able to hit this maybe when the McMichaels address some of these charges. So I'm just going to leave that open right now.
Thank you, Judge. I'm assuming the court wishes us to skip over citizen's arrest duty to inquire proposed by Mr. Goff.
That's Mr. Goff's charge.
All right, and then the state and Mr. Goff both requested the right to resist an unlawful force in making a legal arrest. And for this particular charge, the state took this specifically from 3.16.40 from the pattern jury charges and modified it. And I provided some support for changing this from an officer to a citizen. So I don't know at this point in time if there's any objection to it and whether I need to argue it.
If all we've done is change citizen to person, I don't see there being a problem.
Yeah, I don't.
I didn't know if I need to argue it. I just mentioned we were on it, so if we're good with it, we'll move on.
It's a pattern charge other than that one change.
No, we
correct?
don't want this charge.
We don't believe that it has anything to do with this case.
So I will argue it. No, actually, the pattern is for a police officer. The pattern actually, I believe, and I will pull it up. I will pull up specifically the new pattern charges. And we've got 31640. And what the pattern charges is it's about, it's usually done in the context of someone who's caught with the police and they're on trial for maybe obstruction or felony obstruction. So it normally says a police officer is authorized to use in making a lawful arrest only that degree of force that is reasonably necessary, et cetera, et cetera. And it talks about the officer, the right to use excessive force. It talks about the person being arrested has the right to resist. But what I did was I went ahead and put citizen in place of police officer. Now, I know the court has changed that, and the state does not have a problem with the change to it, which is a person is authorized to use in making a lawful arrest only that degree of force that is reasonably necessary to accomplish the arrest. The mere fact that a lawful arrest is being made does not give the person, as opposed to a law enforcement officer, the right to use excessive force or an unlawful degree of force upon the person being arrested. A person being arrested, even though the arrest itself is lawful, has the right to resist, and it goes on to defend against the other's use of unlawful excessive force. And the reason the judge, of course, we want this in is the jury may believe that a citizen's arrest is actually really happening here, and the state's next step is, well, okay, if you believe that there's a citizen's arrest that's actually really happening here, they have probable cause to go ahead and arrest them. Did Mr. Arbery have a right to resist that arrest because too much force was being used against him in the form of a shotgun? And we would argue that, yes, Mr. Arbery was authorized to go ahead and fight this because Travis McMichael was only authorized to make this lawful arrest using only that degree of force that's reasonably necessary to accomplish the arrest. So we feel this is completely applicable to these facts based on the defense. We have to disprove their affirmative defenses beyond a reasonable doubt, and if the jury believes this was a citizen's arrest, they were acting lawfully, our next argument is they used too much force. And Mr. Arbery was totally within his right, under the law, which he was, to resist that arrest. And we ask for this charge.
Judge, first of all, this is not Mr. Arbery's trial. If Mr. Arbery were on trial for resisting arrest, then he could avail himself to this particular jury charge. It doesn't fit. Okay, number two, the state has to disprove self-defense. The state has to disprove that they were informed enough to make a citizen's arrest, not whether Mr. Arbery, in his mind, experienced something in his mind and what his intent became to resist a citizen's arrest. That is not what the jury has to determine. They are not being asked on any level to determine Mr. Arbery's intent, and this court has forbade the state from going into Mr. Arbery's intent. This charge allows the state to get into his mind and argue his intent. You should not give this charge.
Well, I'm going to only give part of it, though. I think the second paragraph starts getting into some of what you've talked about here. But the first paragraph, which is an accurate statement of the law with regard to arrests, a person is authorized to use in making a lawful arrest only that degree of force that is reasonably necessary to accomplish the arrest. The mere fact that a lawful arrest is being made does not give the person the right to use excessive force or an unlawful degree of force upon the person being arrested. That's an accurate reflection of the law. The second paragraph then starts getting into what may have been going on with Mr. Arbery. The next charge, which is 316.41, that sentence also I think is appropriate, which is one upon whom an illegal or unlawful arrest is being made has the right to resist the arrest with such force that is reasonably necessary to prevent the arrest. So the court intends to remove that second paragraph under 316.40 and charge the first paragraph of 316.40 and also 316.41.
Will Your Honor then consider allowing us to, if you're going to allow the state to argue that Mr. Arbery had the right to resist one upon whom an illegal or unlawful arrest is being made has the right to resist, where would the state get the evidence from to support what Mr. Arbery was thinking and that his actions were in fact his choice to resist an unlawful arrest? Where is the evidence that supports that? Where would they get that from? And again, it's getting into...
Well, I'll tell you what, my thought is it's simply based on the video. I mean, the video itself. They're not going to get into what he was thinking at the time, but if they can present evidence of what happened, which is, I think, the best evidence out there, which is the video, then that's where that... If you're asking me, that's what I'm thinking in looking at this charge.
So you'd be essentially informing the jury that Mr. Arbery, or through the video, allowing the state to argue that Mr. Arbery interpreted that as an unlawful arrest.
I'm not doing anything.
Well, by giving this charge, you're authorizing the state to argue that.
This charge is, I mean, if the state wants to argue that, that's that evidence. They're not going to get into the head of Mr. Arbery other than to say, here's what you've seen. Because I agree with you. That's where the court has maintained
Right.
The entire trial.
I'm sorry. Court will let me know when it's my turn.
Yep. Go ahead, Mr. Schrock.
Your Honor, the court can't. The court actually has the power to do pretty much anything. I didn't mean any disrespect, but the court shouldn't charge half of an excessive force charge and not give the other half. And to the extent that that's the position I'm being put in on behalf of defendant McMichael, we have to withdraw the whole request. The idea that the jury gets to decide if the McMichaels used excessive force, but that they don't get to consider whether the defendant used excessive force, that's just grossly wrong. I mean, and from Mr. Bryan's perspective, this is incredibly important. It's incredibly important. If the McMichael defendants used excessive force, it's an intervening circumstances. Mr. Bryan's off the hook for anything that happens after that. If Mr. Arbery uses excessive force in resisting an arrest, even if it's an unlawful arrest, it's an intervening circumstance. Mr. Bryan is off the hook. If both Travis McMichael and Mr. Arbery are both using excessive force, whether it's mutual combat or just contemporaneous excessive use of force, still, Mr. Bryan has an argument that he shouldn't be held liable for whatever happens at that point. To be coming in and saying that the state gets to argue that the McMichaels used excessive force, but we can't argue that Mr. Arbery used excessive force, that's wrong. And 3.16.4 doesn't mention excessive force on behalf of the defendant. I'm sorry that the state doesn't want to discuss Mr. Arbery's mental state at the time he turned and attacked Travis McMichael. I understand why they don't want to go there. And I understand that maybe the court may be considering the possibility that its 404B ruling, in retrospect, was incorrect. Because in an aggravated assault case, I don't know how you avoid it, but still, if you're going to charge the one half on excessive force, you got to charge the other half on excessive force when both parties have engaged in excessive force. And with all due respect, that's one reason why this tragedy took place. And I think the jury needs to have the full relevant law presented to them and let them sort it out, however long it takes back there.
The state does not have any intention in going into the mindset of Mr. Arbery. Mr. Arbery's dead. I don't know what he was thinking. We do know what he did. We do know what he saw. And it's not us that's contending the defendants were making a citizen's arrest. The defendants are contending they made a citizen's arrest. And so therefore, they contend they're making a lawful arrest. And the law is you have to use a degree of force that's reasonably necessary to accomplish that arrest. And one upon whom an illegal or unlawful arrest is being made has the right to resist that arrest with such force as reasonably necessary to prevent the arrest. This is the law, and we agree that it should be given. We would like the second paragraph in of 3.16.40. However, we leave it to the discretion of the court, but we request both 3.16.40 and 3.1641 based on the video itself.
Yeah.
Can I make one comment on that? Briefly, and I'm just thinking out loud here about the consistency or inconsistency, and if it matters, between saying on the one hand, as the state has said several times, flight or fight, that Mr. Arbery was defending himself against an aggressor on the one hand, and on the other hand, he's simply resisting what he now perceives to be an unlawful citizen's arrest. That sounds to a jury possibly to be a very confusing set of laws, and I'm not sure which way the state will argue. Maybe they argue both and say, hey, take your pick. He's either defending himself against an aggressor with a shotgun, or he is resisting what he considers to be an unlawful arrest. They seem like they both can't be true at the same time.
There's no escape from his mental intent on this, John.
Well, I don't know. The 316.41 is an objective standard.
I'm sorry, I can't hear.
Yeah, 316.41 is an objective standard. It's not subjective.
Point 316.
316.41
41.
Okay.
40.
Okay.
is an objective standard.
So is the previous one.
No.
316.40 is an objective standard.
316.40 actually talks about to the extent that person reasonably believes. So we start getting into the subjective with that. That's why I'm concerned about that paragraph, based
Your Honor,
upon the objection that was raised.
I'm sorry. I didn't mean to cut you off. My apologies. Perhaps the pattern charge needs to be adjusted. But this, when we're talking about an aggravated assault, this is an objective standard, a reasonable person in the shoes of the individual. That is the same standard. The pattern charge, it's basically one pattern charge, and it's the same reasonable person standard, reasonably objective, a reasonable person in the shoes of that person. That's the standard. And with all due respect, that's the reason the state didn't go into a whole bunch of evidence that people were expecting to hear. Because what's subjectively in the minds of the McMichael defendants is irrelevant. It's a reasonable person in their shoes. Likewise with Mr. Arbery. We don't have to get into the mind of the deceased, as if we don't do that in every murder case. We don't have to get in the mind of the deceased. It's what a reasonable person in his position whether their actions are justified or not. There's no difference in the standard between 31640 and 31641, not intentionally, and if there needs to be an adjustment of the wording, that's fine. But clearly, that is the same standard being applied in both. And it is a reasonable person. It is objective, not a subjective standard.
I'm actually going to agree with Mr. Goff on this point for that paragraph. Because, once again, aggravated assault, did the defendants, were their acts such that they would put a person in reasonable apprehension of receiving serious bodily injury? You don't have to know what's in the mind of the person. It's, were their acts such that a reasonable person would feel this way? If the person being arrested, even if it's lawful, has the right to resist the use of excessive force to the extent that the person reasonably believes. So was this excessive to make a reasonable person think it's excessive and they needed to resist it? So on this level, the state agrees with Mr. Goff that the entire charge should be read, but of course we leave it to the discretion of the court.
I just see it differently. There's two separate issues going on, which is a lawful arrest and the degree of force that is allowed in a lawful arrest, which is 31640. And I understand, and that defines what the amount of force that can be used in the arrest. So that in this particular case, that would be Travis McMichael. What degree of force could be used? Only that degree of force that's necessary to accomplish the arrest. Right? Just the fact that he can make an arrest doesn't allow excessive force. So there's the first paragraph. Then in the context of that lawful arrest, you've got the second paragraph. 31641 is actually a different idea. It is if there's an illegal or unlawful arrest being made, what is the right to resist? And that's whatever's reasonably necessary to prevent the arrest. I still read that as an objective standard, but I mean, maybe I'm reading that wrong then.
The state agrees that that's an objective standard on 3.1641.
Okay, well, that's what I was wondering about. I read that as an objective standard.
We agree that we read it as an objective standard, but come back to the question that would be the sort of jury instruction you would be looking at if it were Ahmaud Arbery on trial.
To help the jury understand that he has the right to resist an unlawful arrest with reasonable force. It is totally improper.
Well, I see what you're saying. I see where we're getting hung up on two. I'm getting hung up on something different. I'm getting hung up on the reasonably necessary. You're getting hung up on was he actually thinking that it was an illegal or unlawful arrest?
Which is nothing concerning this case.
I see what you're saying.
This case is about whether they murdered him or not.
Okay. I'm sorry. We were on
Obviously,
parallel
we need a
tracks.
different perspective.
That would be a good charge, and I resist a police arrest.
That's right.
Saying it was unlawful. And again, if it was Ahmaud Arbery on trial, great charge for him. I would be happy to defend that.
Yeah, in no way is the jury seeking to determine whether or not Mr. Arbery had the right to resist what was happening. They are simply trying to answer the question, did Travis McMichael perform a citizen's arrest under the law based on what he understood and believed, and did he have the right to use self-defense?
Okay, so I think I understand here. You're basically saying in this context, normally it's a police officer and an individual who doesn't believe they're being lawfully arrested.
And they get charged with assault or obstruction or something
And
like
they can use
that.
whatever force is reasonably necessary to prevent that
Correct.
arrest.
And the state's problem, of course, is that's exactly what they're going to argue. They're going to get up here and go, they were making a legitimate citizen's arrest, and he's not entitled to do what he did, which is turn around the front of the
Well,
truck.
let's do this then. I understand what's going on here. I guess that would be a concern. I guess the court needs to consider it based on what I hear in closing argument then.
Well, Your Honor, I don't think it is
Well, let me explain, because the defense gets into whether he was resisting or not, or whether he was acting in a certain way at a certain time. All of a sudden this does become a charge that becomes quite relevant.
Here's where I think we would disagree. And I think Ms. Gunikoski would agree with this statement. There's two questions for this jury. did we have the right to execute a citizen's arrest, and were we doing it lawfully? If the answer to either one of those is no, then everything after that makes us the aggressor, and Ahmaud Arbery can't have been defending himself. So that's how this.
Would be defending himself against your unlawful aggression.
Oh, did I say that? This is going on so well. Ahmaud Arbery only had the right to attack Travis if we were not lawfully executing a citizen's arrest. Because otherwise, if we can't meet those two tiers of citizen's arrest, we then are the aggressors. We're pointing a shotgun at this guy, and we didn't have any right to do that. That's the state's case. That's what we've made all the way through when we described the two sentences of citizen's arrest. So that's why we come back to probable cause. If we had the goods to be able to effectuate a citizen's arrest, he could have run away, of course. He could have run away, he could have sat, he could have flipped us off, whatever. But he wouldn't have had the right then to turn around and attack a man holding a shotgun. At that point, we switch out of citizen's arrest into justification and self-defense. So this sentence is only, this charge of 3.16.41 is only valuable if Ahmaud had survived and we were having an argument about what was going on out there. But we're not having that kind of argument. Ms. Denikoski has every bit of law she needs to make her case without this piece.
If I could put one point on co-counsel.
How many people are going to get attacked by?
Well, I'm just having a conversation, I take it, and just to add a point, I think it makes it clear. Citizen's arrest never was completed. It ended. It was an attempted citizen's arrest that stopped at the point of the front of the McMichaels truck. And then it turned, if it was a citizen's arrest at all, up to that point, it then turned into a self-defense case from the defense's point of view, or a self-defense case from the state's point of
Let
view.
me say, I'm inclined to leave it there. I'll continue to think about it because there's more to it than just what happened in front of the truck. There are the various interactions between Mr. Arbery and the McMichaels on Burford. There are a number of interactions mainly Burford is what I'm thinking about, all which is part of this larger interaction, which would be the attempt to detain or arrest, depending on how you want to say that. So if one thinks about it separate from the actual incident that resulted in the death of Mr. Arbery, and we look at it in the broader sense from the moment, for example, the McMichaels left the driveway and were trying to detain him or arrest him, he has the right to resist that in some way or run away, if necessary, to prevent the arrest. That's where I'm getting hung up. So I'm going to keep it in there for the time being. I'll spend some time over the weekend thinking that through, just as there's another charge out there that we need to. But at this point, I'll plan to give it with the understanding I'm going to spend some time thinking it through.
Thank you, Judge. So,
All right,
going on.
We got one standing.
Oh, sorry.
Your Honor, the court might consider the alternative of taking the last sentence under 316.40 and adding it to the sentence under 316.41, because respectfully to learned co-counsel, there is a third issue. That issue is assuming that the arrest of Mr. Arbery was unlawful. Does that convert or translate into a license to kill? I would submit not. The court needs to charge the jury that last sentence. In resisting, the person being arrested would not be authorized to use force that is unlawful or disproportionate to the amount of force necessary to prevent the unlawful force being used against the person. Under these facts, a jury could conclude, arguably, that the arrest was unlawful, but at the same time that the force used to resist that arrest was excessive and disproportionate. Otherwise, what we're doing is we're translating the right to resist an unlawful arrest effectively into a license to kill if we don't explain to the jury what it means to say whether such force is reasonably necessary to prevent the arrest or not. You need that last sentence, if not that whole paragraph, you need that last sentence in 316.40 for the jury to understand the concept that the concept of excessive force applies both to the defendants on trial and to the person that is deceased. And all this talk about whether Mr. Arbery is a defendant might be relevant on issues like how you burden shifting and charges and all. They don't apply here. But in terms of the rules for the use of force, the fact that Mr. Arbery is deceased has absolutely nothing to do with the legal analysis here.
Moving on. Is that okay, Your Honor?
26832.
268. This is criminal trespass. I believe we all had agreed to this, and it was pre-charged.
It was pre-charged.
Correct. And then the state.
I agree. I don't believe I agreed to the criminal trespass charge.
It was in,
I think it's
it was
already
in the
been
preliminary
charged to the jury.
Well, now that the evidence is presented, if there's no evidence to support criminal trespass, then the court should not repeat the charge in closing. We object to that charge.
Court please keep 26832.
And then the state requested duty owed to a trespasser. And the state is requesting this because there's a duty owed by a landowner or his agent to not willfully or intentionally injure a trespasser. And this is based on Mansfield versus Caldwell Construction, a 2000 case. And the duty owed to a trespasser is to avoid willfully or wantonly injuring that person. Even when the property owner knows that it is customary for trespassers to come upon the premises, the duty owed is merely to refrain from willfully and wantonly injuring him once his presence is known, and no duty of anticipating the decedent's presence is imposed. In other words, you can't set traps. You can't go ahead and do something to harm this person. In this case, we thought that it was appropriate to let the jury know that just because they may consider, I don't know if they will, they may consider Mr. Arbery a trespasser, that somehow being a trespasser allowed someone to commit aggravated assault or false imprisonment or shoot him. And that is why we asked for this charge.
Interesting charge if Mr. English were on
I was going to say,
Thank
the
you.
court doesn't plan to charge on it. This addresses a landowner or his agent, and I think there was, I believe, through Mr. English himself, if not one other witness, discussion about whether they were acting as agents for the landowner. So,
And I didn't know if that was going to come out. I had no idea if Mr. English was going to go ahead and, because I filed these in July, say that, oh yeah, they were acting as my agent, and if they had.
so the court does not intend to charge them.
All right, and then we had burglary in the first degree, which everyone asked for, and it is pattern. We have burglary entry amplified, which is pattern.
Your Honor, before we move past 262.11, we don't believe that is an accurate statement of the law. And I would remind Your Honor of the 10 million times that the state referred to the open secured construction site in this case. Under Georgia law, Smith v. State, 226 Georgia Appeals 9 at 11 to 12, previously cited in the charge submitted, a house under construction which is so completed as to be capable of sheltering people, animals, or property constitutes a dwelling under Georgia law. It's not simply whether it's intended or designed. If it is sufficiently complete that it provides shelter for property, then it is a structure covered by the burglary statute. And one can see in the video that the home, while not fully dried in, as a contractor might refer to it, because the doors and windows aren't there, but the roof is there, and the expensive tools and building materials inside are clearly sheltered from the rain and most of the wind, and therefore